Item 30, it's a very serious issue according to us. I'll just state the point. The first is, if your lordship sees, and I believe the High Court has correctly set out a standard of heightened responsibility and accountability, both insofar as judicial review is concerned and the state, and that you will find at pages 24 and 25. Now, applying this very standard, which the High Court ought to have applied, there are 3 or 4 patent flaws. Now, let me indicate what those are. The first, in our respectful submission, if your lordship is pleased to see, the first is that insofar as the environmental clearance is concerned, the entire process, according to us, for this particular project has to be done from the terms of reference stage by the central government and not by the state. The reason is, according to us, this is a category A project. And if it's a category A project, there is a process prescribed in statute, and that process has not been followed. That's point 1. And point 2, the High Court has misdirected itself, and I show your lordships the fact, on thinking that it is category A, when in fact the documents and the record clearly show that it is not category A.
So, Divan,
Yes.
Union of India was very much party there.
I'm sorry?
Union of India was a party before the High Court.
Yes.
Union of India has been heard also.
Yes.
From their side, there is no such objection that they should have been heard or they should have been.
No, it's not a question of Union of India. Lord, it's a question of who carries out the impact study. Because please see what has happened here. Let me just give you a little background. Why were we there before the High Court? We were there before the High Court because in this particular region, year upon year, there are huge and enormous landslides. The most recent was in 2024. In 2024, over 400 people died in the landslide. 400 were confirmed deaths. There was a lot of other destruction, etc., which took place. So the High Court itself registered a suo motu writ petition, and which it is considering with regards to landslides in the Wayanad region because of the enormous death and destruction which had occurred in 2024. In that, as we have averred, there was an oral observation which was made by the bench at a particular time, saying that, look, before all this tunnel activity, etc., starts, you please take permission or come back to the court. That is the reason why we instituted this particular writ petition challenging this environmental clearance. Now, your lordships, now just please take up straight away the EC process first, my lords, and then I'll just take your lordship to it. Please go straight away to the environmental clearance at page 83, the EC notification. Please go to page 83, P1, and the relevant portion is page 109, 7F. Once, according to us, once the process has to be done in a particular manner, it has to be done in that manner. If it is prescribed that it has to be under category A, now please just have a look at the schedule which begins at page 100. Your lordships will see a project or activity, the first set of columns. Your lordship has page 100.
Yes.
The second set of columns is category with the threshold limit A and B. And the third is thereafter you have conditions, if any. Your lordship has that. Now, as far as we are concerned, 7F, this would be a new state highway project, which would ordinarily be category B. Your lordship has that at page 109. 7F. So ordinarily, it would be under category B. Now, what happens here is that there are general conditions which apply. So please go to 112.
Yes.
112. Any project or activity specified in category B, now this is the mandate, will be appraised at the central level as category A if located in whole or in part within 5 kilometers from the boundary of, you will have protected areas notified under the Wildlife Act, 2 critically polluted areas under so-and-so Act, 3 eco-sensitive areas as notified under subsection 2 of section 3 of the Environment Protection Act 1986. Now please go directly, if your lordships would, to the notification which is at page 136. 136. Now this is the most recent in decades-long notifications. Please see the date at 137. You will find 31st July 2024.
High Court has very elaborately dealt with in para 14 this aspect.
Yes.
That High Court has dealt with this aspect very detailed.
No, yeah, I'll just show you the High Court is wrong on this because it has gone on the completely wrong impression that it was category A. I'm going to show you that. Please just see the draft notification at page 137. Please just have a look at it. It refers to, this is, my lords, the most critical area in so far as Western Ghats is concerned, apart from the landslides, etc. So you will have on 31st July 2024 the draft notification for this particular area, Western Ghat area, important from a geographical landform on the fringe of the west coast of India, or sorry, please just have a look at page 137. There is a long backdrop of those recitals at page 137 of the notifications highlighting the importance of the Western Ghats, the Nilgiri Thar, the land-tail macaque, all those wildlife, etc.
Problem in this country is that if the central government, state government, all stakeholders, if they are not conscious and aware of the central guard, and what is the importance of a tunnel in these days for construction of highways?
No, so may I just tell your lordships, the point over here is it's a question of alignment. It's not just any tunnel, and it's not just a tunnel anywhere. In any case,
Mr. Divan, the experts are doing it. It's not that some layman has started
no,
digging a
correct.
tunnel.
So, my lords, I am exactly on that point. I am exactly on that point that where the law itself prescribes that it be done in a particular manner, it deserves to be done in that manner. And I'm going to take your lordships as to where the High Court is in error. Now, just look at page 138.
Mr. Divan,
Yes.
we understand your deviation that it shouldn't have been on the basis of ACAC report.
It is required to be.
It shouldn't have been as per ACAC report.
Yes, yes,
It should have been on the independent assessment of CEAC.
yes. And right from
So-
terms of reference, right from terms of reference, your lordship is right.
So that, and there is another layer to it, that the SE, the State Environment Appraisal Committee
Was
was about to be ending its term. and
Yes, yes.
According to you, in a hurried manner.
No, but
Yes,
then
sir.
it went up to
But
the.
that is exactly where we want you to respond.
Yes, certainly.
If the deviation is
Yes,
endorsed by CEAC through its independent appraisal, and the appraisal itself shows that the terms on which the recommendation is made is at variance from the State Environment Assessment Committee.
yes.
How can we say that the deviation in fact has been a complete reversal or denial of subjective assessment by the central environment?
Okay, so can I just, I'll just leave this aside and just respond straight away to this. What happened, there are two stages, my lords, or actually three. The first and the most important is the terms of reference.
You are
Now, if it is-
of the environment plan.
No, so terms of reference is decided first. So if it is category A, the terms of reference get
goes to the
determined.
central.
Absolutely right. Number one. Now, has that happened here? The answer is no. Then we come to the second stage. The second stage is an appraisal. Now, here again, insofar as appraisal is concerned, it was not done by the central government. It was done at the state level. So that's the second flaw insofar as category A is concerned. And when I'm going to point out now, Miller, I'm taking a leaf from your lordships. Please see how the committee responded. Just have a look at the committee's, the 400 and the meeting of the committee. Please just have a look at it. The central committee's meeting. Second volume. Which page? Please go to page 167 directly. You may go, yes, your lordship will just see 167. Just see when it came to the central government what they did. Please look at 165. Just go directly to 165. Straight away. Now, this is the 397th meeting. And your lordship, would your lordship goes to page 160 for a moment. 160 is where it begins. P9. Para 3.15 on 161 says, terms of reference for the proposal was considered in the 150th meeting of the state EIAA on 30th June 2022. Then please see what they say in para 3.1.25. During the EAC, the committee observed as the following. The committee observed that the tunnel alignment passes through a vulnerable terrain prone to landslides, where massive destructive landslides occurred in 2019 and 2024, necessitating precautions during the post-construction to avert vibration-induced landslips. The project road through the Western Ghats, the impact lies in the Nilgiri Biosphere Reserve, falling within 10-kilometer radius of the project alignment as per the MOEFCC notification dated 31st July 2024, so-and-so district. The area also reports endangered bird species such as so-and-so. 5 bird species are threatened under the IUCN and Red List. 3 vulnerable species, 14 species are endemic to the Western Ghats, and 29 species are Schedule 1 and 155 species are Schedule 2 of the Wildlife Protection Act. The committee pointed out that the project area falls in an environmentally fragile region and vulnerable to landslides, where a high landslide hazard zone and ESA villages. The area recorded that the landslides in the past with high fatalities and experienced an extremely severe landslide disaster with a very high death toll, loss of properties and adverse land modifications in the recent past. Therefore, all the anticipated impacts due to various activities envisaged under the project during the construction and the operation phases must be evaluated. Roman 4, vibration impact of blasting could be felt at influence zone and nearby built structures. It's also necessary to examine the possibility of accentuating the landslide incidents in the area based on a detailed evaluation. It's also necessary to understand long-term mitigation measures for the anticipated impact of the region endangered, endemic and ecological impacts on wildlife. In view of the above, the committee noted that the project has been appraised, now please see this, by the SEIAA issued on terms of reference and requested the project proponent to provide detailed note and presentation on the following aspects. So these are the aspects which the Central Committee requires. Now at the next meeting, sorry.
Everything has been duly considered. The High Court refers to specifically para 12 and 13.
Yes, Meloj, may I just take your lordships to para 12 and 13?
Yes, please.
Just please have a look at para 12, last slide, Meloj, top of page 22.
Oh, you can read right from.
Okay, I'll read from para 12. Meloj, on page 21. We also do not find any merit in the apprehension of the petitioners as regards bona fides of the recommendation of the SEAC at the fag end of the sanctioned term. A perusal of the recommendations clearly reveals that the circumstances which led to the rejection of the earlier recommendations at the hands of the CEAC were considered in extenso by the SEAC, and it was only thereafter that the revised recommendation was made. Further, it was not obligatory for the CEAC to accept the said recommendations of the SEAC, and in fact, the CEAC did not mechanically accept the recommendation made by CEAC. It is also significant that although there were no final notification that notified the ecologically sensitive area in the state, the SEAC and the CEAC took
Note of the village.
note of the villages
Notified.
that were notified and followed the, please see this next line.
Even before the final notification,
Yes,
the at least Central Committee
yeah,
consciously took even the contents of a draft notification in mind.
yes, the why,
Treating
so,
it as a
but that's wrong. This last part is wrong. Just see, I'll just read it.
Yes.
And followed the procedure of getting the project assessed by the CEAC by treating it as a category A project as mandated in the general terms and conditions. So can I just answer that? This is factually incorrect. What happened was, the reason it went to the central government was that the term had ended insofar as the SEIAA is concerned. So there is a paragraph in the environmental impact notification to send it up. That's why it went. It wasn't as if it was a category A project at all. And that is the flaw. This is the reasoning. The flaw is in this. This Western Ghat notification, which your lordship correctly says is a draft notification, has been issued from 2014 onwards. I was about to show your lordship. Every time they keep renewing it and keep it at a draft stage. But for over a decade, everybody... Sorry.
that draft notification has been taken as a final notification
Yes.
for the purpose of environmental clearance.
But then my case is through. Then it must be category A. And there is no category A terms of reference. There is no category A appraisal. Please see, my lords, the conditions which they have eventually put in the second meeting, 401st meeting at page 167. This was accepted. All those conditions are just a cut and paste job of the recommendations which were made earlier. Now, my lords, if there is a flaw, if your lordship accept, well, my lords, I'm obliged to the observation that the central government has treated it as category A. That is correct according to us. Now, if that be so, terms of reference and the full appraisal has to be done at the central level. That has not been done over here. And my lords, when you have such a serious issue, because what has the High Court done? The High Court has merely said, my lords, in our respectful submission, that look, these are technical matters. Fair enough. But then at least this technical procedure has to be followed. If the procedure itself has not been followed as mandated, and because there is some report which is available on record, sorry.
Liberty that at any subsequent stage where if anything happen, you can go to NGT.
Because that observation is only for in the course of implementation. For example, what they have, sorry.
Many precautions have been taken. It's a
Sorry?
project of national importance. After all, that
I
area,
accept that, my lord.
in Kerala, the kind of congestion on road, the highways, it's such a, because the state has its own limitations in terms of availability of land. And therefore, going for a tunnel is something that throughout the world tunnels are being constructed.
My lord,
It's not
but
something
tunnels
we
is
have to
such an
do
ecologically sensitive area. My lord, the objection is not to the tunnel.
everywhere.
The objection is where is the tunnel coming up? It's in a landslide prone area where 400 people have died.
That scientists and engineers will take care. They are in the field. They know everything. They are associated. They are actively decision makers. They will take care of it.
Lord, we feel, my lord, that this is a
If
issue.
anything, God forbidden, if anything moves in the wrong direction, that's why the High Court is also very conscious of this fact. High Court said that yes,
The High
if
Court
at
was
all
so
need be, then you will go to the experts.
My lords, your lordships may just see the history.
This project is already delayed. Every day is,
Just give it.
it has a very
Just
serious
have a look.
consequence.
This is just a summary.
Component.
My lord, this is a summary from some of the landslides which have occurred.
So, landslide, nobody disputing. We know this area.
Yes.
We have been hearing and we are also aware of this fact. Maybe it is only to all.
This
kind
very
of-
village, my lord, it's not some general region. If your lordship sees what I have just handed over to the courtmaster, if your lordship sees the latest one, 30th July 2024, that landslide where there were 420 confirmed deaths, 118 missing. Now, in a situation like this, at least the statutory procedure deserves to be followed. Since your lordship has observed correctly, my lords,
We
that
must be well
this is to
aware
be
of-
treated as category A.
You knowing better than us that how the tunnels are constructed in these days. And
No, that's what has, in fact, that's another objection which we have. Because in the final conditions, they have left the technology, etc. in the EC, which is impugned. They have left the choice of technology to the authority. They have said, there's an elephant corridor. Please acquire this land for the, sorry.
that's why an open ending that if any cause of prejudice, please go to NGT. That liberty, that's why for any kind of step, liberty is there.
They have
It's
said
not
in
that
the
only
course
on
of
one aspect.
implementation. But can I just, now, I think I accept what your lordship is saying, that post, assuming that the EC is sustained, then for other subsequent disputes with regard to implementation, the NGT is available to us. I'm grateful the High Court has made that observation. The question is, if in the issuance of this EC, where category A process has not been followed, isn't the citizen entitled to say, sorry,
Mr. Divan, we would have appreciated this argument if this union of government through the Ministry of Environment were not heard there.
yeah,
They were very much supportive. The
Yeah.
central government, that's why the High Court says, irrespective of the recommendation of the state committee,
Yeah.
we are using the word state.
yes, yes, yes,
SEAC and
Yeah.
SEAC.
yeah,
That instead of state committee, the central committee has applied its mind independently. That is
Yeah.
the finding.
Yeah.
Whether project B, whether project A, the
Yeah.
question is that whether there is a deliberation
yeah,
and application of mind by an expert committee
Yeah.
constituted by the central government under the statute.
yeah.
That application of mind is there. That project they have approved. It's a now question, once they have approved the project,
Yeah,
you may be right that while executing a project, certain issues may arise, keeping the local.
yeah, but that's a separate argument where your lordship is protecting us in the sense by the observations of the High Court. But I'll just make a final request. Just please consider this. What has happened here, which is the second meeting, which resulted in the EC grant, they have not applied their mind in terms of appraisal. Your lordship is, you see, the point being put to me is that the central government was there. Your lordship is right. But the process under the environmental clearance processes, the EIA processes, not central and state alone. These are independent committees with expertise which apply their mind, and then the decision and the call is made. Sorry.
There you are absolutely right.
Yeah, so it's as an independent. Yeah.
These committees are not kind of a government entity.
Yeah, it's not meant to be a rubber stamp, my lords.
They are statutory entity,
Yes, they are statutory.
expected
Yeah,
to act independently,
yeah, yeah.
to utilize their expertise as being specialist in the field.
Yeah.
Absolutely no doubt about that.
Yes.
And that's why we are saying the High Court, that's why the High Court starts with the word that there is no reason to doubt bona fides. Because if they have applied their mind, which had it been a case, central government saying simply, central authority saying simply, we have no reason to doubt about the state recommendations or the state authority.
But that's what's happened, Manoj.
No, that's why please see the High Court, what the High
Just
Court.
see, Manoj, page 174. There's one line.
You see, that's why we are saying the High Court has also examined the report and taken a decision. Let's see that how the project proceed. If this project is executed without any hurdle or without any adverse impact, look at it will become the lifeline for this state. And the tunnel system is the best one only to protect the wildlife, only to avoid this kind of obstruction of the roads and this, as you say, the environmental calamities that have been taking place. Look at the hardship being faced by the people of the area.
These are people, Manoj, the party I'm representing are people from the area, but they've suffered such terrible loss.
That is what becomes a very difficult.
Manoj, I will only say one final point. If your lordship looks at page 173, 174, which is the final clearance, there is no independent application of mind at all by the EAC. I read those paragraphs.
But we
Yes.
would have accepted that.
Sorry?
We would have accepted that argument,
Yeah.
but for the fact
That.
that the
Yeah.
clearance by the central assessment or the appraisal committee
Yeah, yes.
incorporates no less than
Yeah.
58 specific conditions.
So all of
In
those,
addition to it,
Yeah.
and particularly
Yeah.
condition number 33,
33.
yes, which
Yeah.
speaks of an environment management plan on the
Yeah.
basis of which the EC shall be re-evaluated and if necessary be cancelled.
All right. So can I just,
So if
I'll-
that is so, it
Yeah.
would be difficult, and that's what it really
now,
weighed
Manoj,
with the High
our
Court.
study, I'll just respond to this straight away. Our study of the environmental clearance, because your lordship is correctly putting to me that, look, so many conditions have been put. There's an application of mine. That's what's being put to me.
58 or
All these conditions, the material conditions, were in the recommendations of the state SEAC. And they are just cut and pasted over here. That's what the specific averment which we have made. So these people didn't apply their mind. In the first meeting, they said, how are you doing all this through an environmentally sensitive area? Then they said they took everything which was recommended at the state level and put it in here. That's all that happened.
Mr. Divan, the point is that it is not a case where any mechanical decision has been taken. These conditions are very rigorous conditions. And what should be effort of every stakeholder should be that these conditions are meticulously followed and complied with. Once you follow all these things, we see no reason that this project can have any adverse impact anywhere. The only thing is somebody will have to closely watch the compliance of these conditions.
Very
And
well.
for which, fortunately, you have an NGT bench there in the nearby area. I think it is there in Tamil Nadu or in
Chennai.
Kerala itself.
Chennai.
Chennai. So it is, the NGT can appoint a independent observer, can, in case you find that one of these conditions there is a non-compliant, you can immediately approach the tribunal with this approach. Only thing to be done is, once these conditions are followed, we see no reason at all.
There's a point beyond which we can't, my lords, question an individual condition. I can only say that as far as application of mind is concerned, they've bodily lifted all the state recommendations and put them in here. I don't think that's application of mind. That's one. And number two, category A means from beginning to end, it has to be central government. But I'm very grateful.
Say, we have heard Land Senior Counsel for the petitioners at a considerable length. Union of India, the Ministry of Environment, Forest and so on, so is also present. He is also represented by Shri K. Natarajan, Leonard, Additional Solicitor of India. Shri Ranjit Kumar, Senior Counsel
State of Kerala.
for the state of Kerala. We find not only from paragraph 12 and 13 of the impugned judgment of the High Court, but also from the record that the Central Environment appraisal committee.
Central
Assessment.
Expert Appraisal Committee. CEAC
Ah.
is Central Expert Appraisal Committee.
Central Expert Appraisal Committee, in bracket CAC, has accorded approval to the subject project, subject to various conditions. Various conditions. So what is more important is that while executing the subject project, the project proponent must be obligated to meticulously follow those conditions, to comply with those conditions. Also, the High Court rightly felt that in the event any condition is deviated or compromised, or is not complied with, or is not followed or deviated, in that event, the petitioners can approach the National Green Tribunal, as such violation shall amount to accruing of a fresh course of action. In view of the liberty granted by the High Court, we see no reason to interfere with the interim judgment of the High Court. It goes without saying that the petitioners shall be at liberty to approach the MGT, if so required, during the process of execution of the subject project.
As provided in para 15, That is provided in para 15 of the judgment.
That's it. Para 15 of the judgment.
Grateful, grateful.